Hello and welcome to Module 2. In this module, we'll be speaking of the judge and jury and law and fact. The judge's role. Under FRE 104, preliminary questions, A, in general, the court must decide any preliminary question about whether a witness is qualified, a privilege exists, or evidence is admissible. In so deciding, the court is not bound by evidence rules except those on privilege. B. Relevance that depends on a fact. When the relevance of evidence depends on whether a fact exists, proof must be introduced sufficient to support a finding that the fact does exist. The court may admit the proposed evidence on the condition that the proof be introduced later. Now I'll tell you now, ladies and gentlemen, with respect to FRE subparagraph A, we will be discussing the judge's participation in litigation under this rule in a number of the modules. And you will see just how critical this rule is to the overall power of the court to superintend the course of a trial before them. With respect to paragraph B, this is also known as conditional relevance, and you will hear that term used loosely in some of the module discussions as well. FRE paragraph C, conducting a hearing so that the jury cannot hear it. The court must conduct any hearing on a preliminary question so that the jury cannot hear it if the hearing involves the admissibility of a confession, a defendant in a criminal case is a witness and so requests, or justice so requires. And you'll note that under this discussion, there will be a lot of instances in which an objection is made to the admissibility of a piece of evidence in the presence of the jury. Typically, if it doesn't involve one of the first two circumstances, the court under paragraph 3 will decide whether, in terms of the question asked and the objection and the evidence sought, the court will hold the hearing out of the presence of the jury with respect to proffers of evidence and arguments on admissibility. And subparagraph C3 is within the sound discretion of the trial court. Subparagraph D, cross-examining a defendant in a criminal case. By testifying on a preliminary question, a defendant in a criminal case does not become subject to cross-examination on other issues in the case, which means the defendant is not waiving their Fifth Amendment privilege if they testify before the judge on a preliminary question of admissibility. They can't be questioned about other facts in the case. If, however, the defendant then testifies on their own behalf in the trial itself, then, of course, they're subject to cross-examination. And subparagraph E says that evidence relevant to weight and credibility. This rule does not limit a party's right to introduce before the jury evidence that is relevant to the weight or credibility of other evidence. This is a very, very important subparagraph because even though the trial court has admitted evidence, after a consideration of its admissibility, the fact that the evidence can be attacked on weight or credibility is still within the control of the opposing party, that is, the party opposing the admissibility. So there is no waiver of that right simply because the court has admitted the evidence. And you'll see that we will talk later on about confessions, for example, that even though the trial judge rules that the confession is voluntary, that can still be made an issue of weight and credibility before the jury. And there are many other issues which fall well within that scope. Similarly, Florida has a companion statute, Florida Statute 90.105. Note the difference. The federal statute is 104, the Florida statute is 105. Preliminary questions. 1. Except as provided in subsection 2, the court shall determine preliminary questions concerning the qualification of a person to be a witness, the existence of a privilege, or the admissibility of evidence. When the relevancy of evidence depends upon the existence of a preliminary fact, the court shall admit the proffered evidence when there is prima facie evidence sufficient to support a finding of the preliminary fact. If prima facie evidence is not introduced to support a finding of the preliminary fact, the court may admit the proffered evidence subject to the subsequent introduction of prima facie evidence of the preliminary fact. In subparagraph 3, hearings on the admissibility of confessions shall be conducted out of the hearing of the jury. Note this is mandatory. Hearings on other preliminary matters shall be similarly conducted when the interests of justice require, or when an accused is a witness if he or she so requests. And I've already talked about confessions because they are specified in this particular rule. But this can also apply to privileges. It can also apply to claimed unlawful searches and seizures, any of these things. And the trial court can, at its discretion, and probably should, relating to constitutional issues, conduct the hearing out of the presence of the jury. So if the trial court rules that something is unconstitutionally obtained, then it never comes into evidence and the jury never has to consider it. Once again, this is within the discretion of the trial court, but in criminal cases, it's very carefully going to be scrutinized by the appellate courts because they do not want any improper evidence of a constitutional nature to be heard by a jury. That will taint the entire trial. In Celebrity Cruises versus ESEF Corporation, and this is a Southern District of New York federal trial case, pursuant to FRE 104A of the Federal Rules of Evidence, the admissibility of expert testimony is a preliminary question of law for the court to determine, and that's under the Dobert decision, which we will talk about extensively in Module 14. But this is an example how the FRE 104 reaches deep into the substance of trials, to their very nature in certain circumstances. The proponent of the testimony bears the burden of demonstrating its admissibility by a preponderance of the evidence.
In Saavedra versus State, the Florida 4th District Court of Appeals held that Florida Statute Section 90.1051 is patterned after the Federal Rules of Evidence 104A and imposes the responsibility of determining preliminary questions as to the admissibility of evidence upon the trial judge. Therefore, the jury plays no role in the decision whether to admit a co-conspirator's declaration. In Saavedra versus State, the court continued when it stated in adopting the reasoning applied to FRE 801 as precedents, after a ruling on the record that the out-of-court declaration of an accomplice co-conspirator is admissible under Rule 801 D2E, the court may submit the case to the jury. We will be discussing accomplice co-conspirator testimony in a later module, and in addition, I'll point out now that Rule 801 of the Federal Rules of Evidence deals with hearsay testimony, and we will have a lecture on that in another module as well. Continuing, the court should not charge the jury on the admissibility of the co-conspirator's statement, but should, of course, instruct that the government is required to prove the ultimate guilt of the defendant beyond a reasonable doubt. An appropriate instruction on credibility should be given, and the jury should be cautioned with regard to the weight and credibility to be accorded a co-conspirator's statement. And essentially what the court is saying here is that if under Florida Rule 105 the court has a preliminary hearing on the admissibility of a co-conspirator's statement on the issue of whether the individual giving the statement was in fact a co-conspirator, and the court concludes that the individual was a co-conspirator and decides to admit the co-conspirator's statement against the current defendant, the court will not instruct the jury on the admissibility issue that it has just ruled upon, but will leave the issue up to the jury for credibility and weight, just as any other evidence, to be proved by the prosecution beyond a reasonable doubt. In Rimmer v. State, the court stated that it as well stated that the admissibility of evidence is within the sound discretion of the trial court, and the trial court's determination will not be disturbed on appellate review absent a clear abuse of that standard. So this is the appellate review standard when a court admits evidence. It is also the standard if the court refuses to admit evidence. First Union National Bank versus Turney, the First District Court of Appeals. In First Union National Bank versus Turney, the First District Court of Appeals opined that we are guided by our prior decisions regarding admissibility determinations that hinge on preliminary factual questions. We have traditionally required that these matters be established by a preponderance of proof. Evidence is placed before the jury when it satisfies the technical requirements of the evidentiary rules, which embody certain legal and policy determinations. The inquiry made by a court concerned with these matters is not whether the proponent of the evidence wins or loses his case on the merits, but whether the evidentiary rules have been satisfied. So in the last slide we talked about the appellate courts will only review a trial court's decision to admit or refuse to admit evidence under Florida Rule 90.105 on a standard abuse of discretion. However, the threshold standard in determining the admissibility of evidence for the trial court is a preponderance of proof on the part of the proponent of the evidence to establish whatever legal threshold is appropriate. We will be talking about some of those thresholds in later modules. Continuing in First Union, the court said that thus the evidentiary standard is unrelated to the burden of proof on the substantive issues, that is, the merits of the case, be it a criminal case or a civil case. The preponderance standard ensures that for admitting evidence, the court will have found it more likely than not that the technical issues and policy concerns addressed by the federal rules of evidence and have been afforded due consideration. As you can see, they're adopting the federal rules interpretations for this admissibility issue. And in that application, the First District Court of Appeals of Florida stated that, as in Lego versus Twomley, a United States Supreme Court case, we find nothing to suggest that admissibility rulings have been unreliable or otherwise wanting in quality because not based on some higher standard other than preponderance of the evidence. Here, continuing the quote from Lego versus Twomley, a United States Supreme Court case, we think that our previous decisions in this area resolve the matter. Preliminary facts of that a custodial confessant waived rights must be proved by preponderance of the evidence. Inevitable discovery of illegally seized evidence must be shown to have been more likely than not. Voluntariness of consent to search must be shown by preponderance of the evidence. Voluntariness of a confession must be demonstrated by a preponderance of the evidence. The United States Supreme Court's interpretations of Rule 104A in the Federal Rules of Evidence is persuasive authority as to the proper interpretation of Section 90.105(1) of the Florida Rules of Evidence. Note, however, specifically under the provisions of Florida Statute 90.1052, there is an addendum to the general rule as stated in the Turney case. 2. When the relevancy of evidence depends upon the existence of a preliminary fact, the court shall admit the proffered evidence when there is a prima facie evidence showing sufficient to support a finding of the preliminary fact. Prima facie is even less than preponderance of the evidence standard. And we're only speaking of preliminary facts in this particular situation. And that's established by Florida rules of evidence. And that is a lessening of the standard somewhat with respect to the overall preponderance of the evidence standard. In Donaldson versus State, the Florida 4th District Court of Appeals concluded that breathalyzer test results are admissible into evidence only upon compliance with the statutory provisions and enacted administrative rules. Sections 316.9321B1 and 19343, the Florida statutes, provide that an analysis of a person's breath, in order to be considered valid, must be performed substantially in accordance with methods approved by HRS, and that's the Florida Department of Health and Rehabilitative Services. Whether the state has laid the proper foundation for the admission of a breathalyzer test result is a preliminary question under Florida Rule 105, which must be determined by the trial judge when the evidence is sought to be introduced. In Huck versus State, the court opined that the determination of a witness's qualifications to express an expert opinion is particularly within the discretion of the trial judge, whose decision in that regard will not be reversed absent a clear showing of error. Florida statute section 90.702 requires that before an expert may render an opinion, two preliminary factual determinations must be made by the court under Florida statute section 90.105. First, the court must determine whether the subject matter will assist the trier of fact in understanding the evidence or in determining a fact in issue. Secondly, the court must determine whether the witness is adequately qualified to express an opinion on the matter. Here, both requirements were fully satisfied with respect to the testimony of the medical examiner. We will be discussing in great detail the applicability of Section 9702 to expert testimony in Module 14. A medical expert may properly render an opinion as to cause of death by process of elimination. And here we're dealing directly with the rendering of an opinion by an expert medical personnel, the medical examiner in this instance. And this is basically the same standard that veterinarians will be held to, and that is why I'm focusing at this point on this particular case. The 3rd District Court of Appeals analysis in another case, Airley, is instructive as to the admissibility of the medical examiner's testimony. A review of the record shows that the witness was a qualified pathologist, that he conducted a thorough autopsy on the deceased body, and that by a process of elimination he concluded, based on a reasonable medical certainty, that the deceased had died from suffocation or strangulation. He found no evidence of disease, trauma to the body, obstruction to the throat, drugs, insect, or snake bites. He did state on cross-examination that he regarded his opinion as a guess, but he clarified this testimony on redirect examination by stating that this was his opinion based on a reasonable medical certainty. The court said specifically, a medical witness may reach a conclusion by the process of elimination through excluding natural causes of death. This process of elimination will not render the witness's conclusions inadmissible, but merely affects the weight to be given his testimony, which must be determined by the jury. We agree that there is nothing inherently wrong with coming to a conclusion by the use of the process of elimination, and we find no error in the trial court's determination to allow the medical examiner to testify on that basis. The weight to be given to such testimony and its believability are for the jury to decide. Mr. Huck also argues that it was improper for the medical examiner to offer his opinions based on a reasonable degree of medical probability instead of a reasonable degree of medical certainty. No authority is cited for this proposition, nor have we independently located any. In fact, the law in Florida contradicts this assertion. The Florida Supreme Court has held that expert medical testimony as to the cause of death need not be stated with reasonable certainty in a homicide prosecution, and is competent if the expert can show that, in his opinion, the occurrence could cause death, or that the occurrence might have or probably did cause death. And here I want to highlight the difference between admitting evidence and the determination versus the determination of the weight and credibility of the evidence. Since Florida Statute 90.1051 imposes the responsibility of determining preliminary questions as to the admissibility of evidence upon the trial judge, the jury plays no role in the decision whether to admit a conspirator's declaration, and this is an admissibility question for the judge. However, if the defendant is charged with conspiracy, the trier of fact, that is, the jury, ultimately must find its existence by proof beyond a reasonable doubt, and that's a guilt determination and is a jury question. So the admissibility of a co-conspirator's testimony depends upon the trial judge concluding that the individual, by a preponderance of the evidence, was a co-conspirator. The decision with respect to whether the defendant is involved in a conspiracy is for the jury to decide, and the prosecution must prove that beyond a reasonable doubt. In Munkus v. State, the prosecution sought to admit records of Munkus' prior convictions for impeachment purposes only. As a preliminary question, the judge was required to determine whether the records produced were actually those of the defendant Munkus. The prosecution must establish this by a preponderance of the evidence. Once the prosecution satisfies this burden, in this case by showing the same Social Security number, the same dates of birth, and a strong similarity of the names, thus establishing a strong inference of identity, the defendant must offer evidence to disprove the identity issue. On another concept, with respect to the competency of a juror to serve, the test for determining juror competency is whether the juror can lay aside any bias or prejudice and render a verdict solely on the evidence presented and the instructions on the law given by the court. A juror must be excused for cause if any reasonable doubt exists as to whether the jury possesses an impartial state of mind. And the reason I'm pointing that out is this is a determination that's made preliminarily by the trial judge. There is no jury issue with respect to the qualifications of another juror. In a non-jury trial, the law is well settled that the credibility of witnesses and the weight of their testimony are questions for the determination of the judge, whose function it is to draw all reasonable deductions from the evidence. In such cases, the judge is in a position to evaluate the testimony and disregard that which is improper or which has little or no evidentiary value. And here the trial judge is ruling on the admissibility of the evidence under preliminary rulings and then determining whether that evidence is proof beyond a reasonable doubt of the defendant's guilt. So the judge has two roles in a non-jury trial. Let's talk for a few moments about witness competency. First of all, I said the judge supervises the impaneling of a jury. The trial judge has the duty to decide if a challenge for cause is proper, and this court must give deference to the judge's determination of a prospective juror's qualifications. It is well within a trial court's province to determine whether a challenge for cause is proper, and the trial court's determination of a juror competency will not be overturned absent manifest error. A trial court has latitude in ruling upon a challenge for cause because the court has a better vantage point from which to evaluate the prospective jurors' answers than does the appellate court in the appellate court's review of the cold record. Judge's duty to instruct the jury. The defendant had the right to have the trial court correctly and intelligently instruct the jury on the essential and material elements of the crimes charged and required to be proven by competent evidence. However, jury instructions are subject to the contemporaneous objection rule, and absent an appropriate trial objection, an error pertaining to the jury instructions can be raised on appeal only if fundamental error occurs. This again is another determination made by the judge. In the context of jury instructions, fundamental error occurs only when the admission is pertinent or material to what the jury must consider in order to convict. It follows that a failure to instruct the jury on an element of crime is fundamental only when that particular element is disputed at trial. Where an element of the crime is not accurately defined but is undisputed at trial, the error is not fundamental error. Furthermore, for an error in any jury instructions to reach the level of fundamental error, the error must reach down into the validity of the trial itself to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error. In Fisher v. State, the court concluded that every trial judge is responsible for and has the power to enforce the orderly conduct of proceedings before him. He has the inherent power to require that attorneys who appear in cases before him conduct themselves in such manner and follow such procedures as will not interfere with or unduly delay the effective disposition of such cases. This includes necessarily the power to require his consent to withdraw. This power, however, derives from the responsibility to effectively conduct the business of the court. It does not mean that the requirement of consent by the court to such withdrawal includes the power to compel an attorney to continue in the representation of a party when he complies with rules for withdrawing or gives due notice to his client of his intention to withdraw, unless unusual circumstances exist which would interfere with the orderly processes of the court. The function of the jury, on the other hand, we will demonstrate by some preliminary instructions that the Florida courts are required to give. You have now been sworn as the jury to try this case. This is a civil case involving a disputed claim or claims between the parties. Those claims and other matters will be explained to you later. By your verdicts, you will decide the disputed issues of fact. I will decide the questions of law that arise during the trial, and before you retire to deliberate at the close of the trial, I will instruct you on the law that you are to follow and apply in reaching your verdicts. In other words, it is your responsibility, that is the jury, to determine the facts and to apply the law to those facts. Thus, the function of the jury and the function of the judge are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Reaching a verdict is exclusively your job. I cannot participate in that decision in any way. You should not speculate about how I might evaluate the testimony of any witness or any other evidence in this case, and you should not think that I prefer one verdict over another. Therefore, in reaching your verdict, you should not consider anything that I say or do except for my specific instructions to you. Following the final arguments by the attorneys, I will instruct you on the law. The case must be tried or heard by you only on the evidence presented during the trial in your presence and in the presence of the attorneys and myself. You must not conduct any investigation of your own. Accordingly, you must not visit any of the places described in the evidence or the scene of the occurrences that is the subject of the trial unless I direct you to view the scene. Also, you must avoid reading newspaper headlines and articles relating to this case and trial. You must also avoid seeing or hearing television and radio comments or accounts of this trial while it is in progress.
Having heard the lecture with respect to the judge's duty to determine the competency of a witness to testify, I thought it might be fun to throw this journal article in here with respect to Bonobo to pose a question to you, which you can answer to yourselves. I don't need to know the answer. With your background as veterinarians and your knowledge of the relative intelligence of various animals, and having opportunities to view and judge the training of animals, and also to see how animals respond to humans directly and indirectly, I thought it might be fun for you to try to see whether you think, based upon the lecture you just heard, that Bonobo could be qualified to testify in a trial. Just a commentary. Now, some additional duties of the trial judge. The trial judge initially supervises the impaneling of a jury. The trial judge has the duty to decide if a challenge for cause is proper, and this court must give the deference to the judge's determination of a proposition of The trial judge is required to supervise the impaneling of a jury. The Florida Supreme Court has stated that the trial judge has the duty to decide if a challenge for cause, that is, whether a witness should be excluded from sitting on a jury, whether this cause is proper, and this court must give deference to the judge's determination of a prospective juror's qualifications. It is within a trial court's province to determine whether a challenge for cause is proper, and the trial court's determination of juror competency will not be overturned absent manifest error. A trial court has latitude in ruling upon a challenge for cause because the court has a better vantage point from which to evaluate prospective jurors' answers than does this court in our review of a cold record. The trial court also has a duty to instruct a jury. In two instances, some commentaries in initial instructions and then instructions with respect to how they should deliberate and reach a verdict. In Barentios versus State, the court said that the defendant had the right to have the trial court correctly and intelligently instruct the jury on the essential and material elements of the crimes charged and required to be proven by competent evidence. However, the jury instructions are subject to the contemporaneousness objection rule, which means they have to be objected to immediately. And absent an appropriate trial objection, an error pertaining to the jury instructions can be raised on appeal only if fundamental error occurred. In the context of jury instructions, fundamental error occurs only when the omission is pertinent or material to what the jury must consider in order to convict. It follows that a failure to instruct the jury on an element of a crime is fundamental only when that particular element is disputed at trial. Where an element of the crime is not accurately defined but is undisputed at trial, the error is not fundamental error. Furthermore, for an error in jury instructions to reach the level of fundamental error, the error must reach down into the validity of the trial itself to the extent that a verdict of guilty could not have been obtained without the assistance of the alleged error. Judges and the rules of procedure. Every trial judge is responsible for and has the power to enforce the orderly conduct of proceedings before him. He has the inherent power to require that attorneys who appear in cases before him conduct themselves in such a manner and follow such procedures as will not interfere with or unduly delay the effective disposition of such cases. This includes necessarily the power to require his consent to withdraw, that is, the request by an attorney to withdraw from representation in a trial. This power to supervise attorney withdrawal, however, derives from the responsibility to effectively conduct the business of the court. It does not mean that the requirement of consent by the court to such withdrawal includes the power to compel an attorney to continue in the representation of a party when he complies with rules for withdrawing or gives due notice to his client of his intentions to withdraw, unless unusual circumstances exist which would interfere with the orderly processes of the court. Now, I mentioned preliminary instructions. Here is a suggested preliminary jury instruction. You have now been sworn as the jury to try this case. This is a civil case involving a disputed claim or claims between the parties. Those claims and other matters will be explained to you later. By your verdicts, you will decide the disputed issues of fact. I will decide the questions of law that arise during the trial, and before you retire to deliberate at the close of the trial, I will instruct you on the law that you are to follow and apply in reaching your verdicts. In other words, it is your responsibility to determine the facts and to apply the law to those facts. Thus, the function of the jury and the function of the judge are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Reaching a verdict is exclusively your job. I cannot participate in that decision in any way. You should not speculate about how I might evaluate the testimony of any witness or any other evidence in this case, and you should not think that I prefer one verdict over another. Therefore, in reaching your verdict, you should not consider anything that I say or do except for my specific instructions to you. Following the final arguments by the attorneys, I will instruct you on the law. The case must be tried or heard by you only on the evidence presented during the trial in your presence and in the presence of the attorneys and myself. You must not conduct any investigation of your own. Accordingly, you must not visit any of the places described in the evidence or the scene of the occurrence that is the subject of the trial, unless I direct you to view the scene. Also, you must avoid reading newspaper headlines and articles relating to this case and the trial. You must also avoid seeing or hearing television and radio comments and accounts of this trial while it is in progress. Now we'll do an examination of the concept of jury function. The United States Constitution, Article 3, Section 2, Clause 3, deals with trial by jury. And before I recite this, I'll tell you that this applies in this provision under Article 3 only to the federal courts. The trial of all crimes except in cases of impeachment shall be by jury, and such trial shall be held in the state where the crimes shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may by laws have directed. And when they say it shall be tried in the state where the crime was committed, they mean that the federal court that's presiding in that particular state will conduct the jury trial. It is not to be interpreted as the state courts trying the case. In Maddox versus the United States in 1895, the United States Supreme Court stated that the primary object of the constitutional provision in question, the right of confrontation, was to prevent dispositions or ex parte affidavits, such as were sometimes admitted in civil cases, being used against the prisoner in lieu of a personal examination and cross-examination of the witness, in which the accused has an opportunity not only of testing the recollection and shifting the conscience of the witness, but of compelling him to stand face-to-face with the jury in order that they may look at him and judge by his demeanor upon the stand and the manner in which he gives his testimony, whether he is worthy of belief. This is the first and fundamental responsibility of a juror in a criminal case and also, of course, in a civil case, and that is to determine the credibility of the individual who is speaking as a witness. Once they've heard that evidence and made an assessment of that witness's credibility, then they must give what weight they will to that witness. And this is an integrated process that the juror must do with respect to each witness. In Levy versus Doig in 1889, the Supreme Court of Florida said that the right to a jury trial did not exist in the ecclesiastical courts. And those are the church courts in the United Kingdom, nor independent of statute. It has existed in the probate courts of this country or other courts exercising the usual powers of the courts of ordinary. The same is true of the Chancery Court. And we've spoken a little bit about that in Module 1. The Florida Constitution, Article 1, Section 22, addresses trial by jury. The right of trial by jury shall be secure to all and remains inviolate. The qualifications and number of the jurors, not fewer than 6, shall be fixed by law. The number of jurors at 12 in criminal cases is an arbitrary number. It has existed in the English common law and carried over into, first of all, the American colonies and then into our view of what our jurisprudence requires. But you'll see that a jury of 6, especially in civil cases, is quite common in the United States. Section 3 of the Declaration of Rights provides that the right of trial by jury shall be secured to all and remain inviolate forever. This, however, guarantees to the citizens a right of trial by jury only in those cases, civil, that is, not criminal or equity matters, where at the time of the adoption of the Constitution, the law gave that right, and not in those cases where the right and the remedy with it are thereafter created by statute, nor where the cause was already the subject of equity jurisdiction. And in Module 1, we talked about equity jurisdiction, formerly known as chancery jurisdiction. In cases that are bottomed in and fall within the concept of equity jurisdiction and jurisprudence, there is no right to a trial by jury. There are some occasional statutes in various states which permit a trial by jury, even though the proceeding is essentially an equity jurisdiction matter. As an example, the incompetency of an individual in terms of mental disability, which might result in their involuntary hospitalization. There are, in a number of states, statutes which require that in that circumstance, a jury should hear that case. Sometimes the jury is acting in an advisory capacity to court and makes an advisory verdict, and under other statutes, it is a mandatory finding that the judge must apply in these civil disability matters. At any rate, that is the state of the law in various jurisdictions around the United States. The case of BJY petitioners versus MA. I started the case of BJY petitioner versus MA respondent is a clear illustration of the concepts discussed in the Hawthorne case. In this particular case, I will be reading from the opinion of Justice Overton of the Florida Supreme Court. This is an appeal from the decision in BJY versus MA in which the district court, that is the First District Court of Appeals of Florida, declared Section 742.031 of the Florida statutes to be unconstitutional to the extent that it eliminates a putative father's right to a jury trial in paternity proceedings. The relevant facts reflect that BJY filed a complaint against MA seeking a determination of the paternity of her child and an award of child support in accordance with Section 742.031. MA filed an answer in which he denied being the father of the minor child and requested a jury trial. The trial judge granted MA's request for a jury trial, finding that Section 742.031 to be unconstitutional on the grounds that it denied MA the right to a jury trial as guaranteed by Article 1, Section 22 of the Florida Constitution. And keep in mind, ladies and gentlemen, this is a civil case, not a criminal case. So the right to a jury trial under the United States Constitution's Sixth Amendment does not apply. Right to jury trial in Florida. The right to a jury trial is set forth in the Declaration of Rights of the Florida Constitution under Article 1, Section 22. The right of a trial by jury shall be secured to all and remain inviolate. A similar provision has been included in each of our constitutions, beginning with the Constitution of 1838, which became effective in 1845. In the 1838 Constitution, the trial by jury provision read as follows: the right of trial by jury shall forever remain inviolate. In interpreting this provision, this court has made it clear that the Constitution secures to the citizens of the state the right to a jury trial in all types of proceedings in which a jury trial was a matter of right before the adoption of the Florida Constitution originally. The question has also been addressed in the context of whether the right to a jury trial applies only to common law actions as they existed before the adoption of the Constitution, or to both common law and statutory actions as they existed at the time the Constitution was adopted. And here, Justice Overton quoted from Hawthorne versus Panama Park case, which we just discussed. The legislative history of paternity actions in the state of Florida needs to be reviewed for this examination. Again, Justice Overton continued. Before the Constitution became effective in 1845, the territorial law in Florida included the Bastardy Act of 1828. This act permitted a single woman to bring a bastardy complaint against the alleged father of her illegitimate child. The alleged father was then brought before a justice of the peace and required to post bond to ensure his appearance in court. Under the act, the issue of paternity was to be tried before a jury. And this is the 1828 statute. And if paternity was established, the father was required to pay birth expenses and child support. In 1893, the act was amended to permit the father to be imprisoned for a maximum of 1 year if he refused or failed to comply with a judgment in a bastardy proceeding. And that, ladies and gentlemen, would have been in the nature of a contempt of court under current proceedings. Given the history of paternity proceedings, we find that the nature of a paternity proceeding has not changed since 1828. The proceedings under the Bastardy Act of 1828 constituted a paternity action, and the proceedings under the statute today constitute, I'm going to start over with this slide. Given the history of paternity proceedings, we find that the nature of a paternity proceeding has not changed since 1828. The proceedings under the Bastardy Act of 1828 constituted a paternity action, and the proceedings under the statute today constitute a paternity action. Although the process for pursuing the paternity action has changed somewhat over the years to bring the process into the present-day social environment, the proceeding and its purpose are still the same: to establish paternity for the purposes of support. As we stated in re forfeiture of 1978, as we stated, start over on this line. As we stated in re forfeiture of 1978 Chevrolet van, the right to a jury trial is not limited strictly to those specific proceedings in which it existed before the adoption of our Constitution, but should be extended to proceedings of like nature as they may arise. We recognize that of the other jurisdictions in the United States, speaking of other states, that have addressed this issue, a majority have approved the elimination of a jury trial in paternity proceedings. However, those cases can be distinguished because the paternity proceedings were not recognized at common law in those jurisdictions, or there was no right to a jury trial in a paternity proceeding at the time that particular state's constitution was adopted. To say who and who is not speaking the truth when there is a conflict between the statements of witnesses is a question for the jury and to determine, and as to which the court, either trial or appellate, may not substitute its view for that of the jury. And this is Martin versus State, which is obviously a criminal case. District Court of Appeals, in the case before them, said that the appellant and his co-defendants admitted going to the tavern and testified that the altercations occurred, but contend that they were acting in self-defense and that Dennison was the aggressor. The jury heard all of the witnesses and chose to believe the testimony of Dennison, Dolphus, and the other state's witnesses, rather than the appellant and his co-defendants. There is conflict in the testimony, but there is ample evidence in the record to sustain and justify the jury's verdict. This court, sitting as a reviewing tribunal, cannot substitute its judgment for that of the jury as to the credibility of the witnesses and the weight of the evidence. Shoes come in all shapes, sizes, forms, and materials, from the delicate creations of silk and leather or satin and plastic to the cleated, hobnailed, iron-toed boots and clodhoppers of the lumberjack, or the sharp-toed, leather-heeled boots of the cowboy, any one of which may be capable of inflicting grievous bodily harm or death. The records of medical science are replete with case histories of persons being seriously wounded or killed after being struck by the high heel of a woman's shoe or having the boot put to him by a strong man. It is a jury question as to whether or not a shoe or boot constitutes a deadly weapon under all the circumstances surrounding the shoe or boot, its size, weight, and construction, and the manner in which it was used. What's law and what is fact? Jury function and the unanimous verdict. Florida Rules of Criminal Procedure 3.440 provides that when jurors have agreed upon a verdict, they shall be conducted into the courtroom by the officer having them in charge. The court shall ask the foreperson if an agreement has been reached on a verdict. If the foreperson answers in the affirmative, the judge shall call on the foreperson to deliver the verdict in writing to the clerk. No verdict may be rendered unless all of the trial jurors concur in it. This is subject to one exception. The defendant can waive a unanimous verdict, but that must, of course, be knowingly and intelligently waived. In Anders versus the United States, the Supreme Court of the United States said in 1948 that unanimity in jury verdicts is required where the Sixth and Seventh Amendments apply. In criminal cases, this requirement of unanimity extends to all issues, character or degree of the crime, guilt and punishment, which are left to the jury. A verdict embodies in a single finding the conclusions by the jury upon all the questions submitted. Now, the Sixth and Seventh Amendments, of course, apply in this context only to the cases tried in the federal courts. Johnson versus Louisiana in 1972, the Supreme Court reiterated, "We note at the outset that this court has never held jury unanimity to be a requisite of due process of law. Indeed, the court has more than once expressly said that in criminal cases, due process of law is not denied by a state law which dispenses with the necessity of a jury of 12 or unanimity in the verdict." Very briefly, I'll comment on jury nullification. In an excellently written article in 106 Columbia Law Review 959 in 2006, Mr. Rubenstein commented that the role of the jury has changed substantially since the founding of the Republic. In the 18th century, it was commonly accepted that a defendant had the right to a jury, which both found facts and determined whether the law should apply. However, by the end of the 19th century, the jury was reduced to only a fact-finding role. It was no longer charged with determining whether the defendant deserved punishment. As a side note, when I was a prosecutor, and even later in my judicial career, the Maryland Constitution stated that the trial jury was the finder of facts and the law, which, needless to say, gave some interesting comments and resulted in some interesting verdicts. The jury continues to play a nominally pure fact-finding role in today's federal criminal justice system, but some juries still acquit even when the evidence indicates that the defendant has violated the law. Called jury nullification, this type of acquittal is a highly controversial phenomenon. Federal courts universally condemn jury nullification. A brief definition of jury nullification. It is the refusal of jurors to convict a defendant despite their belief in the defendant's guilt. The jury is thus said to be judge of the law, though more accurately, the jury is judging the law's specific application and not its general validity. Juries can nullify for any number of reasons, but types of nullification can generally be divided into several discrete categories. Classical jury nullification occurs where the jury believes that the law itself is unjust, such as when a jury refuses to convict defendants for minor drug offenses. Classical nullification can also occur where the jury believes the law is just, but the punishment is excessive. As applied, jury nullification happens when the jury does not object to the law on its face, but acquits because it believes it is being unjustly applied. For instance, when a jury refuses to convict campus protesters of trespass. Symbolic nullification occurs when the jury does not object to the law or its application, but acquits to send a political message to the executive or legislative apparatus or to society. The grand jury. The First District Court of Appeals in Florida in Duff versus State commented that in the early case of Sawyer versus State, the 1927 Florida Supreme Court decision, it was held that the Fifth Amendment to the federal Constitution, which provides that no person shall be held to answer for a capital or otherwise infamous crime unless on presumption or indictment of a grand jury, it is a limitation upon the federal government and has no reference whatsoever to state action. And this principle was reaffirmed in the Davis case in 1964, and again, of course, in the Duff case in 1965. In a commentary in 33 Florida Jurisprudence Second, Section 265, commenting on the origin and history, the grand jury is a very ancient origin in the history of England, going back many centuries. The grand jury is one of our most ancient institutions, taking shape as we understand it under King Edward III of England about 1368, though its use in some form had been employed as a much earlier date. At the time of the settlement of this country, the grand jury was an informing and accusing body only, without whose previous action no person charged with a felony could, except in certain special cases, be put on trial. The grand jury is designed as a means not only of bringing to trial persons accused of public offenses on just grounds, but also of protecting citizens against unfounded accusations, whether they come from the government or are prompted by partisan passion or private enmity. And they make an observation. In Florida, the grand jury system is derived from the common law, but has been modified by statute. Continuing, they comment that the grand jury's functions are investigative, inquisitorial, accusatorial, or informative, and it can be a combination of any of those four in any particular grand jury proceeding. However, an investigation by a grand jury is not a criminal prosecution, since it is not an ultimate fact finder in the sense of a petty or trial jury. The grand jury's historic role is as an investigative body. It is not the final arbiter of guilt or innocence, and it cannot convict or punish. It's important to remember that. The grand jury simply is an investigative body. The grand jury is regarded as the guardian of all that is comprehended in the public police power of the state, as a means whereby the people participate directly in the administration of their government, and its primary function is to preserve personal and property rights. The grand jury is a means of exposing and determining evil, incompetent, and corrupt government as well. In Skipper versus Schumacher, a 1936 Florida Supreme Court case, the court stated, "The grand jury is an inquisitorial and accusatorial body, organized and acting under and by virtue of the state laws. It can bring a charge by way of indictment, but it cannot convict or punish. It must consist of not less than 15 nor more than 18 persons, and the assent of at least 12 of them is necessary at that time in Florida history to the finding of an indictment. No member of the grand jury can take any effective or lawful action as a grand juror, and in that capacity, except when the grand jury is in session. It is the grand jury as a body and not its individual members acting on their own volition outside the grand jury room, which constitutes an agency of the state to investigate charges of crime, and where 12 members agree to it, to make such charges the basis for prosecution by finding formal indictments." In Klein versus State in 1950, the Florida Supreme Court went further and said, with respect to the judge's charge to a jury, the charge concerning their duties must, of course, be encompassed within the oath and the statutes, but it is well known that by their charge, trial courts have directed the grand jury to investigate every offense that affected the morals, health, sanitation, and general welfare of the county. The charge also goes to the investigation of county institutions, buildings, offices, and officers, and directs them to make due presentment concerning their physical, sanitary, and general condition. The grand jury is, in other words, the guardian of all that is comprehended in the police power of the state. To inquire of all such matters and things as shall be given you in charge, and present every offense against the penal laws of the state, whether any specific punishment is pointed out or not, warrants this. This interpretation clothes the grand jury with broad inquisitorial power, but no broader than judges have construed them to have since the law was promulgated. It would be a strange anomaly to hold that their power to indict or to recommend did not comport with their power to investigate. There are some things, however, that are not within the category of grand jury powers. They will not be permitted to single out persons in civil or official position to impugn their motives, or by word, imputation, or innuendo, hold them to scorn or criticism. Their investigation must be directed to detecting unlawful offenses. They will not be permitted to become the tool of blocks and groups to pry into personal affairs or to oppress someone. Florida Statute 905.101 provides that the grand jury shall consist of not fewer than 15 nor more than 21 persons, and that changes that earlier provision in the case we just discussed a moment ago. The provisions of law governing the qualifications, disqualifications, excusals, drawing, summonsing, supplying deficiencies, compensation, and procurement of petty jurors, and that is the correct way to spell petty. It's a Norman French word. Procurement of petty jurors apply to grand jurors. In addition, an elected public official is not eligible for service on a grand jury. Florida Statute 905.23 states that an indictment shall not be found without the concurrence of 12 grand jurors. Turning once again to 33 Florida jurisprudence, second, juries, it is the policy of the law to shield the proceedings of grand juries from public scrutiny, and it is provided by statute that grand jury proceedings are secret. Grand jury secrecy serves several specific governmental purposes. When a grand jury investigation culminates in an indictment, the indictment is customarily sealed until the arrest of the accused can be effected. Secrecy serves in this context to prevent the flight of accused persons. Witnesses appearing before the grand jury must be free to tell what they know without fear of having to answer elsewhere for their testimony. Likewise, grand jurors must be free in their deliberations to express their opinions without fear of retribution. Similarly, the reasons for the policy of secrecy are generally said to be 1. Protect the jurors themselves, 2. Promote a complete freedom of disclosure, 3. Prevent the escape of a person indicted before he or she may be arrested, 4. Prevent the subornation of perjury in an effort to disprove facts they're testified to, and 5. Protect the reputations of persons against whom no indictment may be found. And that, of course, is after the grand jury has conducted an investigation. This policy is intended to foster the utmost freedom of disclosure to the prosecutor of alleged crimes and offenses. Now, what can be disclosed in general? And we turn once again, this time to Section 334 of 33 Florida jurisprudence. Second, the Florida statutes permit limited disclosure of grand jury evidence for determining the consistency of testimony, 2, determining whether the perjury occurred, or 3, in furtherance of justice. The statutes provide that a grand juror, state attorney, assistant state attorney, reporter, stenographer, interpreter, or any other person appearing before the grand jury may not disclose the testimony of a witness examined before the grand jury or other evidence received by it, except when required by a court to disclose the testimony for the purpose of 1, ascertaining whether it is consistent with the testimony given by the witness before the court, 2, determining whether the witness is guilty of perjury, or furthering justice. In the case of Brandsburg versus Hayes, the United States Supreme Court in 1972 stated that grand jury proceedings are constitutionally mandated for the institution of federal criminal prosecutions for capital or other serious crimes, and its constitutional prerogatives are rooted in long centuries of Anglo-American history. The Fifth Amendment provides that no person shall be held to answer for a crime or otherwise infamous crime unless on a presentment or indictment of a grand jury. And in addition, Article 3 of the United States Constitution has a provision that requires trial by jury. Again, that is applicable to the federal courts. The court in Brandenburg also said the adoption of the grand jury in our Constitution as the sole method for preferring charges in serious criminal cases shows the high place it held as an instrument of justice. Although state systems of criminal procedure differ greatly among themselves, the grand jury is similarly guaranteed by many state constitutions and plays an important role in the fair and effective law enforcement of the overwhelming majority of the states. And footnote 25 states that although indictment by grand jury is not part of the due process of law guaranteed to the state criminal defendants by the 14th Amendment, a recent study reveals that 32 states require that certain kinds of criminal prosecutions be initiated by indictment. In the 18 states in which the prosecutor may proceed by information, the grand jury is retained as an alternative means of invoking the criminal process and as an investigative tool. Because its task is to inquire into the existence of possible criminal conduct and to return only well-founded indictments, its investigative powers are necessarily broad. It is a grand inquest, a body with powers of investigation and inquisition, the scope of whose inquiries is not to be limited narrowly by questions of propriety or forecasts of the probable result of investigation, or by doubts whether any particular individual will be found properly subject to an accusation of crime. Hence, the grand jury's authority to subpoena witnesses is not only historic, but essential to its task. Although the powers of the grand jury are not unlimited and are subject to the supervision of a judge, the long-standing principle that the public has a right to every man's evidence, except for those persons protected by constitutional, common law, or statutory privilege, and they will apply even in grand jury proceedings. Law and fact. Law, that which must be obeyed and followed by citizens, subject to sanctions or legal consequences. The term is used in opposition to fact, and that is from Black's Law Dictionary. Fact, a thing done, an action performed, or an incident transpiring, an event or circumstance, an actual occurrence, an actual happening in time or space, or an event mental or physical, that which has taken place. A definition also from Black's Law Dictionary. Law and fact distinguished. Fact is very frequently used in opposition or contrast to law. Thus, questions of fact are for the jury or the judge in a non-jury trial. Questions of law for the court. Fraud in fact consists in an actual intention to defraud, carried into effect, while fraud imputed by law arises from the man's conduct in its necessary relations and consequences. Law is a principle, fact is an event. Law is conceived, fact is actual. Law is a rule of duty. Fact is that which has been according to or in contravention of the rule. The distinction is well illustrated in the rule that the existence of foreign laws is a matter of fact. Within the territory of its jurisdiction, law operates as an obligatory rule which judges must recognize and enforce. But in a tribunal outside that jurisdiction, it loses its obligatory force and its claims to judicial notice. The fact that it exists, if important to the rights of the parties, must be alleged and proved the same as the actual existence of any other institution. The terms fact and truth are often used in common parlance as synonymous, but as employed in reference to pleading that are widely different. A fact in pleading is a circumstance, act, event, or incident. Truth is the legal principle which declares or governs the facts and their operative effect. Admitting the fact stated in a complaint or other pleading, the truth may be that the plaintiff is not entitled upon the fact of this complaint to what he claims. Thank you, and that concludes this presentation on Module 2.